We are on the record in the Iowa District Court for Jefferson County. Case number FECR 005144, State of Iowa versus Jeremy Everett Goodale. Personally present in court today is Jefferson County Attorney Chauncey Molding, Assistant Attorney General Scott Brown, the defendant, Mr. Jeremy Everett Goodale, and Mr. Goodale's attorneys, Nicole Jensen and Alan Cook. Counsel, I've been informed that the parties and the defendant have reached a plea agreement and that the defendant's going to be withdrawing his plea of not guilty and entering a guilty plea pursuant to the plea agreement. Is that correct, counsel?
That's correct, Judge.
And what, if you could please at this time recite the plea agreement on the record?
I can do that, Judge. We have a similar plea agreement with Mr. Goodale that we had with Mr. Miller. There are some very significant differences. But the basic plea agreement is that Mr. Goodale is going to enter a plea to murder in the first degree. Since the offense was committed while he was under the age of 18, he is not subject to the mandatory life sentence without the possibility of parole. He, however, is subject to a mandatory minimum sentence under case law and pursuant to Iowa Code Section 902.1 sub 2. At the sentencing hearing, the state plans to recommend no more than a minimum of 25 years for Mr. Goodale, with the maximum sentence being life with parole. The other term of the plea agreement, which really is rendered a bit moot, I guess, by the other guilty plea with Mr. Miller, or defendant Miller, is that Jeremy Goodale had agreed to cooperate with the prosecution of State versus Miller. That cooperation agreement is detailed in the plea agreement, and that's not an agreement we entered into with Mr. Miller, so that is another difference. But that's the basics of the plea agreement. I don't think I've missed anything too critical, but it is detailed and will be filed with the court at some point after this hearing. I think you have a copy of it.
I do have a copy of the plea agreement, and Mr. Cook or Ms. Jensen, is there anything regarding the plea agreement that you want to make record on right now?
No, Your Honor. The state's recitation is accurate.
And Mr. Goodale, did you have a copy of this or see a copy of this before today's hearing?
I did, Your Honor.
And you heard what the attorney said. Is that your understanding of the plea agreement?
Yes, Your Honor.
And is it your personal desire to accept this plea agreement and proceed today to plead guilty to the crime of murder in the first degree?
Yes, sir.
And that's in violation of Iowa Code Section 707.2. Mr. Goodale, I'm required by law to personally advise you of your rights and determine if you are pleading guilty because you're actually guilty, and to ensure there's a factual basis for your plea. So I'll be asking you a series of questions. If at any time you don't understand my questions, just interrupt me and I'll go over those questions with you again. Also, you can talk to your attorney or attorneys at any time before answering one of my questions. Do you understand all of that?
Yes, Your Honor.
If at any time you decide you do not want to continue with a plea of guilty, just let me know and I'll stop. Nothing that you would have said up to that point can be used against you at trial. Do you understand that?
I understand.
Mr. Goodale, how old are you?
18 years old.
And how far have you gone in school?
Completed the majority of my junior year in high school.
Do you have any trouble reading, writing, or understanding the English language?
No, Your Honor.
And do you have any physical or mental disabilities that affect you here today?
No, Your Honor.
Are you presently under the care of a doctor, psychiatrist, or psychologist?
No.
Are you under the influence of any alcohol, drugs, or prescription medication?
No, sir.
Have you been advised, or do you understand regarding your U.S. citizenship, are you a United States citizen?
I am, Your Honor.
Okay. Are you presently on probation or parole?
No, sir.
Other than this case, do you have any other charges pending against you?
No, sir.
Have you received a copy of the trial information filed in this case?
I have, Your Honor.
Have you gone over what you're charged with your attorneys?
Yes.
And have your attorneys explained what you're charged with?
Yes, Your Honor.
Do you understand what you're charged with?
I do.
The minutes of testimony which are attached to the trial information are statements and lists of witnesses for the state, what they would purportedly testify to at trial. Have you been able to review that?
I have.
And as a general proposition, do you agree with the statements of the state's witnesses in those minutes of testimony as it relates to the charge of murder in the first degree?
I do, Your Honor.
There are certain essential elements of the crime of murder in the first degree, which you're pleading guilty to today, that the state would have to prove beyond a reasonable doubt to the satisfaction of a jury, or if you decided you wanted to waive a jury trial and try your case in front of a judge. I will now have the state recite for the record those essential elements of murder in the first degree.
Judge, the elements of murder in the first degree are set forth in the plea agreement in paragraph 2, and they are as follows. On or about the second day of November 2021, the defendant struck Nohema Graber or aided and abetted Willard Noble Chaden Miller in striking Nohema Graber. Number 2, Nohema Graber died as a result of being struck. Number 3, the defendant acted with malice aforethought or aided and abetted Willard Noble Chaden Miller, who acted with malice aforethought. And 4, the defendant acted with premeditation, willfulness, deliberation, and a specific intent to kill Nohema Graber, or aided and abetted Willard Noble Chaden Miller, who acted with premeditation, willfulness, deliberation, and a specific intent to kill Nohema Graber.
Mr. Goodale, do you understand that the state would have to prove all of those essential elements beyond a reasonable doubt to a jury or judge in order for you to be convicted of murder in the first degree?
I do, Your Honor.
Do you understand by pleading guilty today that you're admitting to all of those essential elements of the crime?
I do.
And keeping in mind that the court will not permit anyone to plead guilty who claims to be innocent, what is your plea to murder in the first degree, guilty or not guilty?
Guilty.
Mr. Goodale, in order for the court, for me to accept your guilty plea, I must be convinced there's a factual basis. And I'm going to have your attorneys assist you with this next part of the guilty plea. And they're going to ask you about what you did on or about November 2nd of 2021 that leads you to plead guilty to murder in the first degree. Counsel, whenever you're ready.
Thank you, Your Honor. Now, Jeremy, like we discussed, I'm just going to have you tell the court what had happened back on November the 2nd of 2021, and if there are questions that I need to follow up in order to fulfill those elements, I'm going to do that. So I'll begin with, what was it that you did on November the 2nd, 2021 that caused you to be here today?
On November 2nd of 2021, I met Willard Miller at Chautauqua Park. I understood that he had the intent to kill Mrs. Graber. Chaden had brought a bat, among other supplies, to go through with the murder. And had struck Nohema Graber. We then moved her off of the trail, where I then struck her, and she died as a result. Afterwards, we removed any evidence that we could, and that was my recollection of the events on November 2nd.
To follow up, Jeremy, with regard to premeditation, you understood that Shaden Miller had already essentially come up with a plan to murder Nohema Graber, is that correct?
That's correct.
And you understood that Shaden Miller had brought items to assist in the murder of Nohema Graber. He had brought those items to the park with him that day?
Correct. I didn't bring anything with me.
And he had previously asked you if you would assist him if he were to kill Nohema Graber, and you agreed, correct?
Correct.
And just to clarify the record, and you've already made these statements under oath, but on November the 2nd, you observed Shaden Miller strike Nohema Graber first. Is that correct?
Correct. I was posted as a lookout while Shaden struck her in the back of the head with his bat.
And as we've discussed, you understood at that point you had participated in the planning. You were also culpable of what was going on. And upon seeing that Shaden's strike did not kill Miss Graber, you also struck her to ensure that she had passed away. Is that correct?
Correct.
I believe that's an adequate factual basis, Your Honor.
Anything further from the state?
Judge, we believe that the factual basis that's been recited is adequate for the elements as charged involving Jeremy Goodale. We would ask that the court incorporate the minutes of testimony, if you have not already said that. There is a detailed statement that is attached to those minutes. Mr. Cook referenced that in his factual basis with his client that details out Jeremy Goodale's participation in the murder of Nohema Graber. It would include, as it does in his statement, the planning that went into this particular crime that had occurred for approximately 2 weeks prior to Nohema Graber's death. Mr. Goodale in those minutes details out how Mr. Miller approached him and essentially recruited him to be involved in this, and that it was over a grade that that Mr. Miller had in Ms. Graber's class, and that was provided the impetus and the motive behind this crime that Mr. Goodale then joined into with Mr. Miller and committed. So we'd ask that you incorporate those minutes that detail those particular facts as well.
No objection, Your Honor.
Okay. So just for the record, the court, pursuant to a stipulation of counsel, is going to consider the minutes of testimony in considering the factual basis for this matter. And is it also stipulated that all these events occurred in Jefferson County, Iowa?
We so stipulate, Your Honor.
Is that correct, Mr. Goodale?
Yes, Your Honor.
Anything else for the factual basis from the state?
No, Your Honor.
Mr. Goodale, have you fully and completely discussed the charge filed against you and your plea with your attorneys?
I have, Your Honor.
And have you discussed the existence of any possible defenses with your attorneys?
Yes.
And Mr. Cook, other than a general denial, do you know of any defenses that could affect the outcome of this case?
I do not, Your Honor.
Mr. Goodale, are you satisfied with the representation your attorneys have given you in this case?
I am, Your Honor.
And Mr. Cook, have you fully advised Mr. Goodale of his constitutional rights, and are you willing to defend him at trial if he wished to go to trial?
Thank you, Your Honor. I have so advised my client of all his rights, and if he chose to go to trial, I would defend him.
Mr. Goodale, have any threats or promises other than the plea agreement been made to get you to plead guilty?
No, sir.
There are certain rights that you give up, Mr. Goodale, by pleading guilty. I'm going to go through those with you right now. If you continue in a plea of not guilty, you're entitled to a speedy and public trial by jury of 12 people, and their verdict must be unanimous. You could also have your case tried to a judge without a jury if you wish. When you plead guilty, there's not a trial of any kind, and by pleading guilty, you're waiving or giving up your right to a trial. At trial, you'd be entitled to have an attorney represent you, and if you couldn't afford an attorney, one would be appointed for you. At trial, you would have what's called the privilege against self-incrimination. That means you cannot be required to testify against yourself. You'd also have the right at confrontation at trial, which is the witnesses whose names are on the minutes of testimony would have to come into the courtroom, take the witness stand under oath, and testify in front of you, be subject to cross-examination by your attorneys. You also have the right to subpoena witnesses on your behalf and compel their attendance at trial, even if they did not want to voluntarily attend and testify. At trial, you're presumed innocent until the state proves, if ever, that you're guilty beyond a reasonable doubt. And Mr. Goodale, do you understand by pleading guilty, you're giving up all those legal and constitutional rights I just went through with you?
I do, Your Honor.
And is it your desire to waive those rights and plead guilty here today?
It is.
There are certain maximum and minimum penalties associated with the crime of murder in the first degree. Now, this crime usually carries with it life in prison without the possibility of parole, but because you are under the age of 18 when the offense occurred, that there is a possibility of parole. So the maximum term that usually applies to the Class A felony of murder in the first degree, you have a lesser maximum than an adult who committed this offense if under the age of 18. So at trial or at sentencing, it's my understanding the state has said that they're going to recommend a minimum sentence of less than 25 years. Your counsel is free to argue for whatever sentence they feel is appropriate or you want to have ordered, and the court ultimately will make the decision on what the sentence is, but the life sentence with a possibility of parole is required by both the U.S. Supreme Court and the Iowa Supreme Court. There is no fine on a murder in the first degree charge, a felony. There is a requirement that you be jointly and severally liable for restitution of at least $150,000. That's pursuant to 910(3)(b). And that's paid to the heirs of Nohema Graber. There's a possibility that you would have to pay other restitution, court costs, court-appointed attorney's fees, be subject to no contact orders. It's my understanding that that's the extent of the plea agreement, which there will be a full filing later, but Mr. Brown or Mr. Cook, what would you like to add for the maximum and minimum penalties for murder in the first degree?
Judge, I think the maximum and minimums are set out in the code section that I cited earlier. I think you've touched on those. I'm not sure that there's anything else to add to that.
The 902.1 you're referring to?
902.1, I think it's paragraph 2. It's a fairly lengthy code section that details what is available in a Class A felony to a person who is under the age of 18 who is convicted.
And Mr. Brown, would you agree that deferral or suspending of a sentence is available to somebody that is a juvenile that commits these offenses?
I know that we mentioned that earlier in the previous hearing. I was looking back at 902.1. I'm not sure that is listed or contemplated, but whatever is in the code section is what is available to him.
Mr. Cook, regarding the maximum and minimum penalties, is there any record you want to make on behalf of your client at this time?
Your Honor, I believe all of that is accurate, with the exception, I think Your Honor indicated that the state's recommendation would be less than 25. I believe that the agreement is that it would be no more than 25 as a minimum. In addition, when asked about the plea agreement originally, I think both parties failed to mention that count 2 would be dismissed at defense cost. But other than that, I have no other additions or comments on the maximum and minimum penalties.
Judge, I believe that's an accurate clarification of the plea agreement. It is stated in the terms of the plea agreement as Mr. Cook indicated, and that is true also with regard to count 2.
And I guess, Mr. Cook and Ms. Jensen, have you gone over Iowa Code Section 902.1.2 with your client?
We have not, Your Honor.
Do you have it available in front of you?
It'll be won't, Your Honor.
Okay.
Judge, when they're done, I want to clarify one thing with regard to 902.1.
We're ready, Your Honor.
So, Mr. Goodale, have you had the opportunity to review that code section 902.12 with your attorney?
I have, Your Honor.
And before I ask you the next question, I'll have the state make whatever record they wanted to make on the.
Judge, I'm not sure this is going to make that much of a difference, but I want to make sure we're clear. The way that I read 902.1 with regard to a sentence of probation, it does not say the court cannot do that. It indicates in the code that you have one of three options, which is commitment to the custody of the Department of Corrections. It does not indicate, I believe, that the sentence can't be suspended. We certainly don't contemplate that in this case, but as far as clarifying the record, I think this is what we had mentioned in the previous hearing. It is at least silent with regard to that. So whatever the court thinks its options are under 902.1 are what they are. So that's all.
Anything else from the defendant on this issue?
Your Honor, in reviewing 902.1 with my client and hearing the state's comments, we agree with Mr. Brown's statements with regard to 902.1. We believe that there are three options that Mr. Goodale has afforded to him at sentencing, and he understands those options.
Is that correct, Mr. Goodale?
That is correct, Your Honor.
And just for the record, I'm just going to read 902.12, and the language in 2A states, notwithstanding subsection 1, a defendant convicted of murder in the first degree in violation of section 707.2 and who was under the age of 18 at the time of the offense was committed shall receive one of the following sentences. Subsection 1, commitment to the director of the Department of Corrections for the rest of the defendant's life with no possibility of parole unless the governor commutes the sentence to a term of years. 2, commitment to the custody of the director of the Department of Corrections for the rest of the defendant's life with the possibility of parole after serving a minimum term of confinement as determined by the court. 3, commitment to the custody of the director of the Department of Corrections for the rest of the defendant's life with the possibility of parole. So, anything else we need to go over on maximum and minimum penalties, counsel?
Not mistaken.
No, Your Honor.
Mr. Goodale, any questions or anything else regarding the mandatory maximum and minimum penalties for this charge?
No, sir.
Mr. Goodale, I'm also required to tell you that a plea of guilty may have adverse consequences such as the loss of the ability to vote, to possess firearms, or to receive federal or state benefits. Mr. Goodale, do you understand that I am not bound by any plea agreement reached between you and your attorneys in the state, and that if you persist in this guilty plea, the outcome may be less favorable to you than what the guilty plea or the plea agreement is.
I do, Your Honor.
And keeping in mind all the things we have just discussed and all the rights you're waiving, do you still wish to do you still wish to plead to the crime of murder in the first degree in violation of Iowa Code Section 707.2?
I do.
Okay. And Iowa Code Section 703.1, aiding and abetting, I also believe is applicable in this proceeding. Counsel, anything I've left out of the record that could affect the validity of the plea?
No, Your Honor.
No, Your Honor.
Any reason the plea should not be accepted?
No, Your Honor.
No, Your Honor.
Okay. It is a finding of the court on the record made the defendant is acting voluntarily. He understands his rights and the consequence of his plea, and there is a factual basis for the guilty plea as made. The court therefore accepts the plea of guilty in this matter to the charge of murder in the first degree, violation of Iowa Code Section 707.2 and 703.1. Court hereby orders that a pre-sentence investigation be prepared by the 8th Judicial District Department of Corrections, and that report be filed no later than 3 days before the date of sentencing and made available to counsel and the court. Counsel and the court will go off the record to look at dates for sentencing. Mr. Goodale, in between now and sentencing, I must inform you that any challenge to your plea of guilty based on any alleged defects in this plea proceeding must be raised by a motion and arrest of judgment. That motion must be filed no later than 45 days from today's date, and in no case later than 5 days prior to the date and time set for sentencing. A failure to raise motion and arrest of judgment challenges precludes you from raising those challenges prior to sentencing. My understanding that there is an agreement that you will not challenge your guilty plea post-sentencing pursuant to the plea agreement. Conditions of release, I will just state, Mr. Goodale, that you will not be eligible for bond pending sentencing. Is there anything else regarding record?
Not from the state judge, thank you.
No, Your Honor.
Mr. That concludes the record.